You're at the top of your game, a respected professional, a true expert in your clinical field. But the second you agree to become an expert witness, you're stepping into a whole new world, and it's got a brutal set of rules. You see, your clinical knowledge, that's just the ticket to get in the door. The real challenge is surviving the legal gauntlet. So let's just cut right to it. Here's the big question. You know the medicine, you know the science, you live and breathe the standard of care. But can you actually defend your opinion when you're under oath, with a lawyer trying to pick apart every single thing you say? That's the million-dollar question, isn't it? All right, before we even get into testifying, you've got to understand the battlefield. The legal system isn't just one giant thing. It's really split into two completely different worlds, civil and criminal. From the outside, they might seem similar, but trust me, they play by completely different rules. And the single biggest difference? It all comes down to something called the burden of proof. Now, in a civil case, and this is where most medical malpractice suits live, the standard is preponderance of the evidence. The easiest way to think about it is just 51%. Is it just more likely than not that the doctor was negligent? That's it. But in a criminal case, whoa. The standard is beyond a reasonable doubt. This is the highest bar in our entire legal system. We're not talking 51% here. We're talking about near certainty. And that's why a criminal conviction carries so much weight. Now, here's a crucial point. Just because you have an expert opinion doesn't mean a jury is ever going to hear it. See, there are these really strict rules of evidence. And in the middle of it all sits the judge, who acts as a gatekeeper. It is their job, and their job alone, to decide if your testimony is reliable enough for the jury to even consider. If you don't pass that inspection, you're out. Your opinion never sees the light of day.
And believe me, this whole gatekeeper thing didn't just appear out of thin air. It's evolved a ton. For almost 70 years, there was this simple test called Fry. But then, in 1993, a huge Supreme Court case called Daubert completely changed the game. And just recently, in 2023, the rules got even tighter. So let's talk about the old way, the Fry standard. It was pretty straightforward. It basically asked just one simple question. Is the science or the method you used generally accepted by your peers? If most of the other experts in your field said it was good science, then it was in. Simple, right? But it had a big flaw. It was really slow to adapt to new science that was perfectly reliable, but just, well, new.
And then came Daubert. And this was a massive shift in power. Suddenly, general acceptance wasn't enough. The Supreme Court said that from now on, the trial judge has to act as the gatekeeper. They have to personally, actively evaluate whether your methods are scientifically sound and reliable. The responsibility basically shifted from the entire scientific community onto the shoulders of one person, the judge. Which brings us right up to today. In 2023, they amended the rule, Federal Rule of Evidence 702, and made things even stricter. Now it's crystal clear. The lawyer who hired you has to prove to the judge, by a preponderance of the evidence, that your expert opinion is based on reliable methods. If they can't do that, your testimony is out, period. The gate just got a whole lot tougher to get through. So you're probably wondering, how does a judge even make that call? How do they decide if your science is reliable? Well, they don't just wing it. The Daubert case actually laid out a framework, almost like a 4-point inspection for your testimony. Under Daubert, the judge is going to look at 4 key things. Number 1, testability. Can your theory actually be tested? And just as importantly, can it be proven false? 2, peer review. Has it been published? Has it been scrutinized by other experts in the field? 3, error rate. What's the null rate of error for the technique you're using? And finally, number 4, general acceptance. Is it widely accepted in your scientific community? And notice that last one, general acceptance, that was the entire old Fry test. Now it's just one part of a much, much tougher inspection. Okay, so understanding the rules is one thing, but what happens when you get it wrong? This is not some academic exercise. The consequences aren't just about losing a case for the lawyer who hired you. They can be personal, they can be professional, and they can be absolutely devastating. Let's start with the most important lesson of all, which comes from the case of Dr. Melvin Fly. When you take that stand and give sworn testimony, you are under oath. And lying under oath, well, that's not just a bad idea. It's a crime. It's called perjury. Dr. Fly, a surgeon, was accused of misrepresenting his credentials and his own malpractice history while he was on the stand. So what happened? We're not talking about a fine or a slap on the wrist. He was arrested on criminal charges. He had to post a $50,000 bond and hire a criminal defense lawyer. That's how fast you can go from being an expert witness to a criminal defendant. Now, I want you to look at this number. Over 300. That's roughly how many cases Dr. Richard Dellerson testified in as an emergency medicine expert before his entire career came to a sudden screeching halt.
So, what happened? The Florida Board of Medicine found a pattern of, let's call them misrepresentations. He'd claimed a board certification that had expired. He claimed to have attended Johns Hopkins. He actually tried to argue it was all merely careless, but the board wasn't buying it. Their decision? They permanently revoked his medical license. Just like that, his career, both in medicine and as an expert, was over. Now, our third case is a little more complicated, and in some ways, even scarier. Dr. Nancy Epstein didn't lie. She didn't misrepresent her credentials. She simply gave a clinical opinion that her own professional society, the American Association of Neurological Surgeons, didn't agree with. And for that, they suspended her. The fallout was immediate. Attorneys who had hired her for other cases started dropping her like a hot potato. Why? Not because they thought she was wrong, but because they knew the other side would use that suspension to destroy her credibility in court. This just goes to show, even if you do nothing legally wrong, you can still face career-ending consequences for daring to challenge the status quo. So with all of these landmines out there, legal, professional, financial, how in the world do you protect yourself? Well, it all boils down to one thing: your unwavering ethical compass. Here is the absolute key takeaway. Your professional duties as a doctor, as a nurse, as a healthcare professional, they don't stop when you walk into a courtroom. Major medical organizations like the AMA have made it clear they consider providing expert testimony to be the practice of medicine, and that means it is subject to the exact same peer review and board investigations as your clinical work. And that leads us to the single most important rule in this entire game. Your duty is not to the attorney who's writing you a check. Your first, your last, your only primary duty is to the truth. You are there to be an advocate for your honest, professional opinion, not to be a hired gun for one side of a lawsuit. Look, the legal system desperately needs good, ethical experts to help juries and judges understand incredibly complex medical issues. The need is absolutely there. But the real question you have to ask yourself isn't about your clinical knowledge. It's about whether your integrity, your commitment to sound methodology, and your dedication to the truth are strong enough to handle the fire. Is your integrity ready for the stand?